topic that we will be dealing with today is theories of divorce, and we have Mrs. Inya K as our resource person. On 8 May 2021, we had a session on sources and schools of family law. Now I'm going to present the review of that class. Actually, this review is prepared by Ms. Kartika Babu. Okay. Then, as we all know that family is a basic unit of the society and it's a miniature of the social organization. The family is guided and regulated by family customs, social customs and legal regulations. Family is a branch of law which governs the formation of a family and the rights and obligations arising out of such a relationship. Regarding the sources of law, Hindu system of law has the most ancient pedigree of the systems of law. The study of sources of Hindu law is the study of various phases of its development. It would be convenient to classify the various sources under the following two heads. They are ancient sources and modern sources. Ancient sources under this head for the following four sources, there are Shrutis, Smritis, Digests, and commentaries and digests and customs. Shruti. The word Shruti literally means what was heard. The Vedas thus contain the divine revelation. The term Shruti stands for four Vedas. They are Rig Veda, Yajurveda, Samaveda, and the Adava Veda. The Vedas are said to be the sources of all knowledge, and the Vedas depict the way of life of our early ancestors. Then comes Smriti. The word Smriti literally means what has been remembered. In theory, the Smritis are based on the memory of the sages who were the repositories of the sacred revelation. And the Smritis may be divided into early Smritis and the later Smritis. The former are called Dharma Sutras and the later are the Dharma Shastras. Dharma Sutras were written in prose. A few of them were written both in prose and verse. And the main Dharma Sutras are Gautama, Bodhayana, Abhastamba, Harita, Vasishta, and Vishnu. And Dharma Sutras deal with the duties of men in their various relations. And again, next is Dharma Shastras. The latest Smritis or Dharma Shastras are mostly in metrical verses and are later in age than Dharma Sutras. They are in a sense based on the Dharma Sutras, but they are not metrical renditions of the Dharma Sutras. And Dharma Shastras deal with the subject matter in a very systematic manner. Then comes Manusmriti. The Manusmriti, as we know that it is considered to be the supreme authority in the entire country, and the Manusmriti is divided into 12 chapters and it contains 2,694 slokas. And it is the most authoritative reservoir of law, and the Manusmriti is a landmark in the legal history of India and is a great reservoir of concept of law, legal rules and institutions. Then comes Yajnavalkya Smriti, and it is written by Vijaneshwara, and he classifies a law into three heads. They are Acharya, Vyavahara, and Prayaschitta. Then comes Narada Smriti. It is made in 200 AD and it is considered to be an important legal code. It was the first code which is mostly free from moral and religious feelings. And the Narada Smriti is outstanding that it deals with the law of procedure and pleadings in detail and with remarkable clarity. Then comes the next important sources, that is Digests and Commentaries. The law contained in Smritis were subjected to various interpretations called commentaries. On the Manu Smriti, several commentaries have been written. The important ones are Kaluga Bhakta's commentary and Govindaraja's commentary, that is Manutika. And of all the commentaries, Vijaneshwara's commentary, the Midakshara, is considered to be more important and the most outstanding one. And the Midakshara has been accepted throughout the country except in Bengal. And the next is Dayabaga, uh, which is considered to be a digest. Then comes the another source of or the another ancient source of Hindu law, that is custom. And as we know that certain essential conditions are there to accept custom as a valid one, and these are the essentials of valid custom. It should be ancient and unique, and it should have been in perpetuity, and it should not be uncertain and vague. It should be reasonable and rational, and it should not be immoral, and it should not be against the public policy. Then only we can accept the custom as a valid one. Then regarding the modern sources, and under this head for the following items, they are equity, justice, and good conscience, and precedent, and also legislation. Then moving on to the schools under Hindu law. These are the major schools of Hindu law: the Midakshara school and the Dayabaga school. And Midakshara school is one of the most important schools of Hindu law. It is a running commentary of the Smriti written by Yajnavalkya, and the school is applicable in the whole part of India except in West Bengal and Assam. And the Midakshara has a very wide jurisdiction. Then comes Dayabaga. Okay, Dayabaga school is predominantly prevailed in Assam and West Bengal area, and it is considered to be a digest for the leading Smritis. And it is it then its primary focus was to deal with partition, inheritance, and joint family. And according to Kane, it was incorporated in between 1090 to 1130 AD. So these are the main important schools under Hindu law. Now moving on to the Muslim law. Muslim law is applicable to Muslim, as we know that, and a Muslim is a person who subscribes to the basic tenets of Islam. And the Muslim text writers maintain two conditions to be satisfied to be Muslim. First one is a person who believes in the unity of God. The second condition is that he should believe that the Muhammad is a messenger of prophet of God. So then only a person can be considered to be a Muslim. Then regarding the sources of Muslim law, it can be classified into two heads. They are primary sources and secondary sources. The primary sources, first of all, Quran. The Holy Quran contains revelations of divine origin, and this is the primary and ancient source of Muslim law. And it contains about 6,000 verses, and it is the fundamental source of Muslim law. Next is traditions or Sunnah or Ahadith. The Sunnah or Ahadith is a tradition or precept of Prophet or a usage of Prophet, and it is some kind of practice and precedence that is to be followed by the Muslims. Then comes Ijma. Ijma is an essential feature of Sunni school. The word Ijma means the agreement of the jurists among the followers in a particular age on a particular question, and it can be said to be consensus of a juristic opinion. Then comes Qiyas. It means analogical reasoning. They are the conclusions drawn from a given principle, and by this method, All the Quranic principle and various commentaries are to be critically studied, and after that a deduction or a new principle can be arrived. Anyway, the Qiyas is the Qiyas is considered to be the lowest source of Muslim law. Then comes the secondary sources. Uh, First one is Ijtihad and Istihsan. It is the doctrine by which the interpretation and reinterpretation of Muslim texts can be made on basis of reason. And Istihsan literally means the juristic equity. Then comes the custom or of. The word custom means any kind of usage followed by the people of a country from time immemorial, and it has a force of law. To uphold a custom, it must be reasonable, as we know that. Then comes judicial decisions. And next one is legislations, though the Shariat Act of 1937 was considered to be a landmark legislation in this regard, and there are certain other legislations like Waqf Act 1954, Child Marriage Act, Marriage Restraint Act 1929, the Resolution of Muslim Marriage Act 1939, etc. Regarding this, regarding the schools under Muslim law, it can be broadly classified into Sunni schools and Shia schools. The Sunni schools can again classified into Hanafi school, Maliki school, Shafili school, and Hanbali school. Then Hanafi school is the first and the most popular schools in Muslim law. And before being named Hanafi, the school was known as Kufa. The in relation to with respect to Maliki school, it gets its name from Malik bin Anas. He was the Mufti of Medina. Then comes Shafi school. According to this school, they considered Ijma as the important source of the Muslim law and provide a validity to the customs of the Islamic people, and follows more method of Hanafi school. Next is Hanbali school. Ahmad bin Hanbal is the founder of this Hanbali school, and he founded the school in 241 AD. Then comes Shia school. Here also there are three schools. Itna Asharis, the Ismailis, and the Zaydis are the three schools coming under this category. Now, finally, the Christian law. Regarding the sources of Christian law, we can classify the sources into four major heads. They are the scriptures or the Holy Bible, or the traditions, reasons, and experiences. Regarding the scriptures or the Holy Bible, it is made up of books that were written over a period of 1,000 years, and it contains letters, history, genres, and poetry. And the Bible can be divided into two sections. The first one is the Old Testament, and the second is the New Testament, which contains the life of Jesus. Traditions, initially traditions were interpreted as the teachings of Jesus Christ to his followers. Then the followers recited to the teachings to the Christian people. Today, it has come to be associated with the approaches that guide the different Christian groups. Okay,